Hi, this is Mitchell Flaherty from B6 Real Estate. Thank you for joining today, and thanks for Rob Sudagapkor, my partner, in hosting these webinars at Stratco Property Solutions. Our guest today is James Marino from Cutler Marino, and we're going to be giving an MCI and Regina update. So Rob, I'll hand it over to you for the first question for James.
Thanks, Mitch. So as we know, the Regina case provided a pivotal change for, hopefully a pivotal change for landlords this past spring with its appellate win. Jim, can you outline how the Regina case may impact the MCI legislation from the HSTPA in 2019 as far as potential changes or revisions based on that case law?
Sure, Rob. The essence of Regina, which applied to certain types of rent overcharge complaints, was the essential unfairness of the application of the new rules under the HESPA, which were the big changes to the law, rent stabilization law in 2019, applying to ongoing cases retroactively. The court had found that certain changes in laws can be applied retroactively, but when there's a big impact to the extent that it impacts on a litigant's due process rights, then it would be essentially unfair to apply it retroactively. And that's what the Regina court found with respect to overcharge complaints. So the same type of analysis can be made with respect to the changes that HESPA made to the MCI process. With MCIs, it's really all about the value of the MCIs, whether the changes to expand the amortization rate or whether to apply a reasonable cost schedule or to reduce the cap from 2% where it was previously 6% on collection. All those things make it harder for a landlord to recover their money. And so the question then is, if Regina is applied, what kind of a due process impact does it have? And I think it has a big impact on MCIs.
So does that mean, let's say, for example, we filed for an MCI in 2018, and based off of the 2019 legislation, we have to go by the new formula and the new caps. Are you saying that with the Regina case, it's potentially that this can be reversed and it can't be applied retroactively?
Yes, what we're saying is and that's a good example, because what the essence of this would be that the landlord decided to spend a certain amount of money in 2000 and let's say early 2018, with the expectation of receiving what was then no more than a 6% cap on collection, amortization rate, of 68 months, and so they spent that money and they applied during the time when the recovery was expected, and now they've changed the rules in the middle of the game, and the landlord hasn't received an answer from DHCR. So it's unfair to the landlord. So that would be the type of due process argument that we would make.
So is there cases now where the landlords have been litigating this? Do we have to wait for litigation to happen?
Well, you can make I'm sorry.
One more question.
Yeah.
I want you to give us all the answers. Do we have to wait for the litigation? Do we have to wait for the answers from the courts? Or should the landlords automatically do this and wait for the tenants to litigate it?
The landlord should be making these arguments within the context of whatever they're filing. If they have an existing filing, they should be supplementing their filing with these arguments. If they have a new filing, which is based upon work that was done while the old rules were in effect, they should also be making the argument, because they had the expectation there as well, even though they haven't technically filed yet. Once we get into late 2021, which would be more than 2 years beyond the enactment of HESPA, then the landlord won't be able to make those arguments anymore, because then they'll be basing their applications upon work that was done after the rules had changed, and they didn't have the expectation to spend the money under the old rules.
Okay, so just a summary before I know Mitch has a few questions related from his own clients. So you're saying if we filed an MCI application, or we did work prior to June 2019, as part of whatever response we got from DHCR, we should give a response based off of this this litigation to have it adjusted based off of the Regina case? Is that what
Yes.
you're proposing?
Yes, you should be citing Regina in support of your contentions that it's just an unfair due process impact on my application to apply the new rules when I spent the money and did the work and the building and the tenants benefited under when the old rules were in effect.
And the landlord should not unilaterally increase the amounts without DHCR consent.
Right, and the landlord couldn't do that anyway because in an MCI, you apply for the increase. So you have to wait for the order to be issued anyway. And the quest here is to get an order that has the better rules that result in a better increase for the landlord. Got
it. Mitch, give us your questions.
Yeah, so thanks, Rob. So are there any other legal arguments against the new AII's rules, and MCI rules other than Regina?
Yeah, there is an ongoing a federal case brought by various landlords and landlord organizations against the unfairness of the new rent stabilization rules overall. But they're making arguments that are essentially similar to what the court found in Regina. They're more expansive because they touch upon other things other than what Regina touched upon, which, as I mentioned, was just a rent overcharge matter. So to pull those arguments out, it's essentially the same as what the court found in Regina, but I would make the arguments fairly expansive and continually cite constitutional due process in addition to citing the Regina decision.
Okay, another question in relation to that. Do we have to wait for litigation to occur to get clarity on how Regina or any other arguments would impact these new rules?
No, I think it's important to make the arguments now and you create your own case. And it's possible then that particular landlord's case will become the leading case for good or for bad. And then you can just appeal from there. But it's important to make the arguments now because once you get a decision at the main level, at the rent administrator's level, at DHCR, you're bound by all the arguments, and you can't make new arguments on appeal. So you have to make the arguments now to preserve the record.
Okay, great. Thank you. I think that concludes today's session. We wanted to keep it short and sweet. Hope you found it informative, and we'll be back again with other topics to discuss. Thanks again, both of you.
Okay, thank you.